So every day I talk to landlords and I look over their cases, I skim over their ledger, and I ask them sometimes simple questions like, what are all these things that I see and why haven't you charged your tenant for them? We're talking all about things you can charge to your tenants today. Let's get started. So part of this is a mindset thing. Landlords sometimes feel a little bit icky charging their tenants for more than just the standard amount of rent. But there are potentially multiple things already in the lease that the tenant has already agreed to pay for. If you're just not charging them for it and waiving these fees every single time, I guess that's okay, but why would you do that? The first, and the one that I think bothers me the absolute most, is when a landlord fails to assess late fees. Your lease probably says in pretty plain English when late fees can be assessed and to what extent. And different states have different rules. For example, in the state of Texas, there are rules having to do with multifamily units and rules having to do with single family units and the maximum amounts that are allowed in both. If you don't know what the limits are in your state for your particular type of rental, find that out. That's important information. But once you know what these limits are, it's important to be able to enforce those limits as stated. What I tell landlords in the state of Texas is quite simple. For a single family home, you're capped at about 12%. You should collect that full amount within the first 7 days. And if you're not, then you're just not charging enough. Some people have old language that was appropriate maybe a decade or two ago, but that just doesn't cut it when it comes to late fees. And I ask him to think about the amount of money you're assessing on a daily basis to your tenant for paying their rent late. It's such a small percentage of their actual rent. Do you think it is in any way prohibitive? And the answer that I usually get is, well, I didn't really think about it. Yes, that's pretty obvious. By not thinking about these things, you're likely not to make an impact with the late fee provision, and you're also likelier to simply be dismissive of it. It's not that much money anyway. Instead, what you should be doing is using the late fee provision in your lease as a mechanism, not necessarily to make more money, but to make a very distinct point. The fee itself should be prohibitive. If within a week they've tacked on an additional 12% of the rent, that's gonna make a statement and hopefully prevent rent from being late anytime quite to that extent in the future. By standing firm on your late fee provision, you're going to encourage good behavior and discourage bad behavior. In the process, you're also going to make more money. You know, one thing that I like to collect on a regular basis are thumbs up. If you like what you're seeing, please give us one. Any questions or comments? I like reading them. I like responding to them. I'll see you then. People love animals. It happens all the time. I know it. I'm a dog guy myself. But when it comes to pet violations in the lease, we sometimes let our love of animals blind us to the fact that pets poop and they pee all over the place. And sometimes bad pet owners let pets do bad things to rental property. Because of that, you have a prohibition in your lease of any pets being there without your prior written consent. But if you're not enforcing that, particularly the parts that say violation comes with a cost, you're waiving damages and possibly losing money in the process. Don't do this. If you know that your tenant has an unauthorized pet on the property and they have no basis for having it there, they certainly didn't get written permission from you, you should assess the pet fee, and if there is a daily cost, assess that daily fee and issue a notice to your tenant. Make sure they know you got to get rid of this pet. It's already causing damage, and because of that and the fact that you agreed you wouldn't have it, you got to get rid of the pet. Now, you may ultimately decide that the tenant can keep the pet. That's okay, but have they met all of your requirements, and do they pass all of the restrictive boundaries that you have set for your own property. Perhaps your insurance company doesn't allow certain breeds of animal. Perhaps your city ordinances prevent a certain type of animal from being domesticated on the property. You need to know what these limits are, and you need to abide by them, as does your tenant. Additionally, if there was an assessment of pet rent or a pet deposit that remains unpaid, before that tenant can get out of breach, they need to cure this element of it. Don't just let it slide. Make sure you enforce it, whatever otherwise makes sense for your property. Get it signed, get it paid, and then rest assured that if there is damage, you are covered. Another one that just really gets under my skin is this issue of repairs. I have sometimes landlords who come to me and say, Ernie, these people are destroying my property and I don't know what to do. Well, when did this start? Well, it started 3 years ago when, and I'm going to stop you right there. Are you saying that you've had tenants for 3 years who've been destroying your property and you're just now bothered by it? I don't know that I'm as bothered by it anymore because you allowed this to happen. When you know that tenants are damaging your property, you need to act quickly. Number one, you need to issue notice. That's a violation of the lease, and you need to make sure that your tenant knows this. Number two, you need to repair that damage and repair it quickly so it doesn't get worse. Number three, if you know that the tenant caused this damage and you know that this damage was not from ordinary use or normal wear and tear, then along with repairing the damage, you need to assess that cost against your tenant. Read your lease. What does it say about stuff that the tenant breaks, again, outside of normal use and outside of ordinary wear and tear? If you can charge your tenant to repair what they broke, you should every time. And you should do it early so that it doesn't get worse. You know, there's an element of your own cause in not repairing something when you first found out about it by just kind of sitting on your hands and doing nothing about it and letting it get worse. You know, the tenant might point to you and say, look, you allowed this to get worse, or I really wasn't the sole cause. And your ability to prove that over time diminishes. So by acting quickly and charging them for something you can prove they caused, again, over and above normal use and over and above ordinary wear and tear, you're likely to preserve the status of your property, and you're the most likely to be able to recover these costs from your tenant. If you wait to the end and let it snowball into an enormous sum, you're a lot less likely to, number one, have enough in the security deposit to cover it, and then number two, to be able to get it from your tenant in one fell swoop. Do it quickly, do it when the problem is small, and you're likely to prevent great big catastrophic damage. And by doing this, you're going to be able to maybe keep a tenant who pays for all their own oopsies. Or if you move on from them, be able to get a new tenant in without very much rehab because you were able to preserve the condition of the property pretty well the same throughout that tenancy. If your homeowners association has assessed a fine on you for something that your tenant has done and you're not passing these costs to your tenant immediately, you're probably not understanding your lease very well. What does your lease say about HOA fines that the tenant incurs from their behavior? It probably says they got to pay them. But if you are paying them and not passing these charges along to them, you're sending a pretty distinct message that they can get away with bad behavior, they can violate the lease, they can even cause you economic damage, but you're cool with it. Don't send that message. As soon as you get a fine, make sure you're passing that, not just a copy of the notice, make sure you're sending them a bill. And again, you're using your application of funds clause so that the next payment you receive covers that debt first. If your lease allows you to do that, make sure every time you are doing that very thing. Don't let HOA fines just slide. Don't tuck them under the rug. Make sure you address them and make sure you collect them. Has a tenant ever paid with a check that bounced? If you've got a provision in your lease that charges them the bank fees that you get every time they pay you with an NSF, charge your tenant. Send them this amount. Make sure that if it's in the lease, you are charging it to them. Make sure that they know that because you were assessed a fee, they are responsible for paying it. Again, don't just let it slide. It's something that's important. It sends a bad message to just let it go. Make sure that once you get paperwork from your bank, that you're forwarding bills to your tenant saying, this is something you have to cover. Your lease says this. My bank has charged me that, and now it's time to pay. What about your time? Sometimes a tenant will call you over for the most ridiculous things, or sometimes you're there because you absolutely have to be there. There's some incident or some issue that you have to address. Is it possible for you to charge for your time to do things that are not par for the course, that are something that you have to do because the tenant has violated their lease? Well, if you establish in your lease, perhaps in your house rules, for example, but if you establish in your lease that if you have to step in and take care of anything on their behalf for something they did in violation of the lease, where your time was taken up because of it, but you've established a rate at which you can charge, then yes, of course, you can assess a cost for the amount of time that you spent doing X, Y, and Z, again, due to their violation. If your tenant has caused a mess that you go in and have to clean up, but you've already agreed on the rate for your time, and it takes you 3 hours one Saturday afternoon to take care of it, then yes, definitely charge them for any of your economic costs that you spent, but charge them also for your time in accordance with what your lease already says. Lawn maintenance is an easy thing that sometimes tenants simply neglect. And if you have to go out there and do it, we've covered, can you charge for your time? You sometimes can. But what if these are things you can't do or you simply don't have the time to do, and so you hire a service to come in and take care of the responsibility that otherwise belongs to your tenant? Can you charge them for these costs? And the answer is probably yes. Take a look at what your lease says about their obligation. Take a look at what their lease says about what happens if you have to step in and perform duties and tasks that are otherwise theirs. I would start off, just to make sure you're covering your bases, by sending a notice and saying, look, the grass is getting too tall. I'm getting letters from the HOA, or I drive by all the time and I see that it's just too tall. Please cut the grass on this schedule in accordance with the lease. And if they don't do it and you continue to get letters, or you continue to see that the grass simply isn't getting cut, you could, again, after notice, send your guy over to cut the grass and then issue a bill to your tenant. If your lease is crystal clear, and if you have given notice, and if you incur a cost strictly because of the violations of the tenant, of course you're going to send a bill, and of course you're going to collect it. Make sure your tenant knows that any time you have to step in and assume responsibility for something they should have in violation of that lease, any cost that you incur, they're getting billed for it. Yes, collecting rent is important. Yes, collecting fees for things that are owed under the lease, absolutely wonderful. But remember that this exercise isn't necessarily about getting as much as you possibly can from your tenant, so much as it is making sure that your tenant understands where the boundaries are. If they step past that boundary and cause you economic harm, it's important that they know, don't do that again, and now that you have, you owe this much for it. By establishing these rules and enforcing them every single time, you're actually likely to create a better tenancy, or you're going to find out very quickly that the tenancy is just not tenable. By enforcement of these rules and having a tenant refuse to abide by them, you're going to know quickly, and you will have established for a court, should it come to that, that you gave notice, that your rules were clear in your lease, and that the tenant had ample time to resolve these issues, but simply refuse to. By setting up each of these, you're likelier to get possession back of your property and get rid of a tenant who's unwilling to simply follow the rules as stated, and to make sure that your property is well taken care of just like they agreed to do. Landlords constantly have to resolve problems on their own because a problem left unresolved is ultimately going to snowball into a catastrophe, and you can always prevent that. For other videos just like this about how to best manage your own property, YouTube seems to think that this one right here is absolutely perfect for you. Watch it and any of the other content that you find on this channel. But until next time, landlords, happy leasing.